in order to set up an express trust, the certainty of intention, certainty of subject matter, and certainty of objects. And we're going to go through a problem question and apply these concepts that I have shared in previous videos. So, the problem question reads, the will of Alyssa contains the following provisions. So this already tells us that it is a testamentary trust because it is in her will. So I hereby leave A, £5,000 to be shared amongst my best friends at Warwick Pony Club. The identity of my best friends should be determined by my best friend Bonnie. So that's the first provision. Then provision B, £20,000 to my son Conrad in full confidence that he will see my daughter Daisy through her university education. Then provision C, most of my book collection to my sister Emily. Provision D, my cinema room to my son Fred to distribute one DVD to any of my friends who comes forward to claim it. And provision E, whatever is left to belong to Gary absolutely. So the situation is that Alyssa has just died and we have to advise her trustees in regard to the validity of these provisions. So I like to go for it chronologically and take one paragraph for each provision. That's how I would answer the question in an exam. So provision A has certainty of intention and certainty of subject matter, but what should strike us is the certainty of objects. This might be problematic. So it doesn't state that the trustee will have a discretion in regard to the distribution of the assets. So in the absence, always the equitable maxim, equity is equality, takes charge. So this was held in the case of Doyley in 1735. So this means essentially that because it says here amongst my best friends, and there's no discretion given to the trustees as to how, it means that they will get the money in equal shares. So this is important to establish because knowing whether it is a fixed or discretionary trust tells us what type of test we need to follow for certainty of objects, which seems to be problematic in this case because best friends doesn't seem like an ascertainable and certain object. So now that we know it is a fixed trust, we can follow the certainty of object test of a fixed trust, and this requires that a complete list has to be provided. This is found under IRC versus Broadway Cottages, 1955. So, can we create a complete list of best friends? This is very unlikely because the term is so vague and they won't be able to provide evidential certainty either, and this is required in a fixed trust. So therefore, in this provision, it is highly likely that it will fail. And what happens if a provision fails or a trust fails due to lack of certainty of objects? The money returns to the estate on resulting trust. Estate in this case, because it is a testamentary trust. Otherwise, it would return back to the settlor if this were an inter vivos trust, but the settlor is dead, so it goes to the settlor's estate. So moving on to provision B. Provision B has certainty of subject matter and certainty of objects, but the certainty of intention seems to be lacking. So the words used by Alyssa, in full confidence, that should ring a bell, because we know that in Rhea Adams and Kensington in 1844, these were held to just be words of desire and not to amount to duty-imposing words which are required for certainty of intention. However, we should also be alerted that in the later case of Comiskey in 1905, where the words of in full confidence are also used, this is held to create a valid trust, but this is only because in that case later there is another statement by the testator directing that his assets are to be distributed in a certain way. So if we go back to the problem question, there is no later provision stating a direction that it is important that her daughter Daisy is definitely going to be brought through her university education. However, to gain a few extra marks in the problem question, we can add in that if there were a later provision in the will which may not be included in what we've been initially provided with, that it could still be amounting to certainty of intent if there were a later provision in the will that we have not been provided with that amounts to duty imposing direction. But on the information that we have, this is not likely. So what happens if it fails on on certainty of intention? In that case, the money would be given to Daisy as an absolute gift, and she does not have any legal obligation to use it for her education, because it will just be held to be the motivation and the motive behind giving her the gift, as found in Lassens versus Tyranny, 1949. So this provision will fail as well. Now moving on to provision C. Provision C, this is very clear. This will simply fail on certainty of subject matter because it is clear that the phrasing or the wording of most is not certain enough. So if we look to the case Peck versus Halsey, this is clearly just a word of desire and not a duty imposing word, and we can say that this is because most can be in many different ways perceived. So it could be most economically valuable, most sentimentally valuable, most in terms of number. So there's really no way to say with certainty here what the subject matter is, and therefore this provision will fail. And what happens when a trust fails due to lack of subject matter? There will be a resulting trust back to Alyssa's estate again. So, provision D, this is a clear example of a gift subject to a condition precedent, and we should instantly recognize here that this is a Reed-Barlow 1979 case. So, in this case, it was held that the certainty of object test in a situation of a gift condition to a condition precedent will only require that at least one person can satisfy the condition. And if we think it is very, very likely that an average person will have at least one person in the category of friend, so it is very likely that Alyssa will have at least one friend, and therefore this provision will be held valid. Then moving on to provision E, this is a standard residue clause after a series of specific provisions which we worked through above, and therefore there is no Spranger and Bernard vagueness, and therefore the provision is valid, because we will remember that in Spranger versus Bernard, where it is not clear what the rest amounts to, there cannot be a trust. However, in this case, because the requests above and the provisions were specific, it will be held valid in this case. Thank you very much for listening. Feel free to leave any comments below, and don't forget to follow me on Instagram at legally.blonde.laura. Thank you very much. Bye.